My name is Kyle Wasser. I am a Colorado and Executive Office of Immigration Review licensed attorney. I am doing this presentation on behalf of the Justice Center in Colorado Springs, Colorado. Although this video will be discussing legal topics, it does not create a lawyer-client relationship, and I strongly urge you to seek an attorney if you apply for any immigration benefit. Today we'll be discussing U non-immigrant status, otherwise known as a U visa, and VAWA applications. Both of these cases are potential options for people who are victims of domestic violence and other crimes, and are related. However, they are separate and distinct applications. Some people can file for one or the other, and some people can file for both. To begin, we need to explain an important concept in immigration known as inadmissibility. It is extremely important to understand this concept because it affects every application that you can possibly file. Inadmissibility is a law codified in Immigration and Nationality Act 212, and it is best described as the following. If you've done something bad under immigration law, you will not be able to file for an immigration status or entry into the United States unless there is a waiver or an exception for specifically what you've done. There are many things that can make someone inadmissible. The most common are entering without inspection and committing certain crimes. However, there are many other things, such as being poor, having tuberculosis, or being a member of the Communist Party that makes someone inadmissible. There are many kinds of different waivers and exceptions depending on the type of application you file, and it is important you speak to a competent immigration attorney before you file for any status to make sure you're not inadmissible. So remember, inadmissibility means doing something bad under immigration law that renders you ineligible for other immigration benefits. A second important but simpler concept to explain is discretion. Immigration in many cases has discretion to approve or deny you, depending on the facts and circumstances of each case. For example, having 25 speeding tickets might not make you inadmissible under the Immigration and Nationality Act, but immigration might deny your case in their discretion because that many speeding tickets indicates that you will not follow the laws of the United States. Remember, many cases are discretionary, and if there are a lot of negative factors in your case, USCIS might deny it. These two concepts will be important to our discussions of U visas and VAWA. U visas. U visas are visas given to victims of certain crimes provided they meet all the elements of the case. To win a U visa, we must prove three basic things. First, we must prove you were the victim of a qualifying or similar crime that occurred in the United States or an area controlled by the United States, such as a military base. This means you, generally speaking, cannot qualify for crimes that occurred in other countries. Qualifying crimes include domestic violence, sexual assault, rape, felonious assault, which is difficult to define, but generally assaults that rise to the level of felony, murder, witness intimidation, and false imprisonment or unlawful criminal restraint. Additionally, similar crimes and criminal attempt can count as well. For example, if someone fires a gun at you but misses, it would qualify as an attempted murder and a felonious assault. You can also qualify if you are an indirect victim of certain crimes, such as a sexual assault on your U.S. citizen child who is incompetent to assist law enforcement due to age. Although this is not in the statute, there is also the requirement that the criminal activity must be reported to law enforcement. This is because they must certify that you are helpful in the case. This is called a Supplement B. If the case is not reported to law enforcement, it is almost impossible to acquire a U visa, unless you have a protection order or something similar that went in front of a judge. Therefore, the criminal activity usually must be reported to the police or other law enforcement in order to qualify. Second, we must prove that you suffered serious physical or mental abuse. Generally speaking, I think it is best to try to prove both, so I highly recommend attending therapy if you are able and asking for a diagnostic letter from your therapist to prove your mental harm and retaining all photos and medical records of your injuries to prove physical harm. Remember, you only have to prove one or the other, but it's best to prove both. For example, if you have a harassment-based domestic violence case, you can still qualify for a U visa even if there is no physical harm if you can prove serious mental abuse. Third, and most important, you must prove that you were helpful in the investigation or prosecution of qualifying criminal activity. I like to explain it like this. Helpfulness is the absence of unhelpfulness. Clear as mud, right? What I mean is you must avoid being unhelpful, such as not showing up to testify in court or refusing to cooperate with the police. For example, if you are the victim of domestic violence, but you don't want to see your abuser get in trouble, so you decide not to testify, you will lose your U visa case. If you're the victim of a crime, but you don't want to answer the police officer's questions because you're not a snitch, you won't qualify for a U visa. As a counterexample, you should not panic or be worried if your abuser pleads guilty before the case goes to trial. Even if you are unable to testify, you will still be considered helpful in the case. Another example is if you are the victim of a random shooting by an unknown person and there is never an arrest. As long as you cooperated with the responding law enforcement officers, you will be considered helpful. There is no requirement that there is an arrest or conviction in the case, just that you are helpful in the investigation and or prosecution of criminal activity. If you are the victim of a crime, make sure to keep in contact with the investigating officer and the district attorney's office. I have personally seen people lose their cases because they did not update the district attorney's office with their new address or telephone number and miss their court date. You must comply with all reasonable requests for assistance in the case, even after your Supplement B is signed. So to sum up, there are 3 basic aspects of a U visa application: victim of a qualifying crime, serious physical or mental abuse, and helpfulness in the investigation and or prosecution of the case. Steps of a U visa case. There are 2 steps to a U visa case. The first step is filing for something called an I-918 Supplement B, usually just referred to as a Supplement B. This is the law enforcement certification signed by the police, prosecutor, or judge that states that you are the victim of a qualifying crime and that you were helpful in the investigation and or prosecution of the crime. You must have a signed Supplement B in order to file for a U visa. Otherwise, USCIS will reject your case immediately. The second step is applying for the actual U visa with USCIS. You're proving 3 basic elements of the case. You suffered from a qualifying crime, you were helpful, and you suffered from serious physical or mental abuse. There is a 4th element you must also prove: that you deserve a favorable exercise of discretion. If you remember, we spoke about discretion already. Proving discretion can be easy if, for example, you do not have an extensive criminal or negative immigration history, or very difficult if you have been arrested or participated in criminal or negative immigration activity. U visa are obtaining the signed Supplement B, law enforcement certification, and filing the application with the USCIS. Why file for a U visa? Why would you want to file for a U visa? First, let's talk about the negatives of the application. U visas are notoriously long processing. They can take around 4 to 5 years to receive the initial approval and deferred action. This may increase or decrease in the future, and there's nothing you can do about the processing times except wait. However, despite the processing times, there are some great positives about the U visa. First, it is a path to permanent residence and legalization here in the United States. As you may know, permanent residence, or the green card, is the best immigration status that you can have. It is also a path to citizenship after having permanent residence for 5 years. Second, you can include certain members of your family, depending on your age and marital status. If you are under 21, you can include your spouse, parents, children, and siblings who are under 18 and unmarried. If you are 21 or older, you can only include your spouse and children who are under 21 and unmarried. Although U visas take a long time to process, there is something called the Child Status Protection Act, which basically states that even if someone ages out and turns 21, as long as the petition was filed before they turn 21, it remains valid as long as they remain unmarried. Third, you are eligible for an extremely broad waiver of inadmissibility known as the I-192. Remember that we discussed inadmissibility before? The I-192 can waive almost anything that makes you inadmissible, including the permanent bar and previous removal orders. The only thing it does not cover are waivers needed under national security and terrorism grounds, which are extremely rare. However, it should be noted that the I-192 is a discretionary waiver, meaning that USCIS will review your case in its entirety and decide whether to waive your inadmissibility or not. If you have negative immigration or criminal history, you should provide evidence and documentation of why you deserve a favorable exercise of discretion. Because it can waive virtually anything, it is an option for people who do not have other options in immigration. So to summarize, the bad thing about a U visa are the long processing times, but the good things is that it is a path to permanent residence and legalization. You can apply for certain family members and waiver of most forms of inadmissibility. U visa conclusion. U visas are a powerful tool for victims of crimes. It allows them to legalize their status here in the United States, provided they meet all the requirements. Although it takes a long time to process, the benefits are very high. The most important thing is to report the criminal activity to law enforcement. VAWA Introduction. VAWA is an acronym for Violence Against Women Act. It is a limited but extremely powerful tool for victims of abuse from U.S. citizens or permanent residents. It is open to both men and women. Violence Against Women Act is merely the name of the law that created the program. In order to qualify for VAWA, you must prove that your U.S. citizen or permanent resident spouse, parent, or child subjected you to battery or extreme cruelty, and you are otherwise admissible to the United States. To summarize, VAWA is an application based on your familial relationship to a U.S. citizen or permanent resident who subjects you to battery or extreme cruelty. VAWA explanation. The most common type of VAWA case is based on marriage to an abusive U.S. citizen or permanent resident. You must prove your marriage was entered into in good faith, meaning you did not get married for immigration reasons, and that you resided together. This usually involves evidence such as bills, rent or mortgage statements, and any other documentation. I usually tell my clients that I can use any document generated by someone else that has both you and your abusive spouse's name on it. However, even if you don't have this evidence, other evidence, such as affidavits from yourself or other U.S. citizens or permanent residents, copies of text messages and recordings, or other probative evidence can work to prove your VAWA case. You must also prove that your abuser was a U.S. citizen or permanent resident. However, if you do not have direct proof of this, don't worry. You merely need to give as much information as you have to USCIS, such as your spouse's full name, date and place of birth, social security number, and any other relevant information, such as their alien number. Preferably, you can submit their birth certificate, U.S. passport, or certificate of naturalization, or copy of their permanent resident card to prove that they are, in fact, a U.S. citizen or permanent resident. Third, you must also prove you're the victim of battery, which means physical abuse, or extreme cruelty, which can be any abusive behavior, but is generally demeaning, controlling behavior where your abuser will not let you leave your house, see your family, or threatens you based on your immigration status. It is not required for you to report the abuse to the police. However, it is extremely helpful and goes a long way to proving your case. The best proof of the battery or extreme cruelty is a police report, but other good evidence includes an affidavit of witnesses to the abuse, affidavits from social workers, copies of protection orders, copies from emails, texts, or other recordings of the abuse, and any other credible evidence that you can use to prove that you are the victim of battery or extreme cruelty. You must also prove that you are currently married to your abuser or were divorced within the last 2 years. This is a hard rule. If you wait 2 years and 1 day after your divorce, you cannot file for VAWA. Usually, to prove this, you must submit a copy of your marriage certificate. You can usually get this from the court in the county in which you were married. With VAWA cases, inadmissibility can be a big issue, but many things that make you inadmissible are waivable under a VAWA application. And additionally, if you're required to file for a waiver, such as an I-601, for example, for misrepresentation, it is usually much easier to win. We will discuss later on how inadmissibility affects VAWA-based applicants. You must also prove you are a person of good moral character. You must prove that you do not have a significant criminal history, amongst other things. You must send an affidavit of good moral character, meaning a letter that explains your criminal history if you have any, and swearing that you are a good person of good moral character, as well as a criminal clearance letter from where you have lived for the past 3 years. For example, if you moved from Juarez, Mexico to Colorado 2 years ago, then you would need a clearance letter from Juarez and one from the Colorado Bureau of Investigation. To summarize, you must prove good faith marriage, residence with your abuser, you are the victim of battery and or extreme cruelty from your spouse, you are currently married to your abuser or were divorced within the last 2 years, you are otherwise inadmissible, and you are a person of good moral character. Types of VAWA cases. There are 2 kinds of VAWA cases, VAWA only and VAWA-based adjustment of status. There is also VAWA-based cancellation of removal, but that is a defense against deportation and won't be covered here. The basic difference between a VAWA only and a VAWA-based adjustment of status is whether you are eligible for adjustment of status based on your inadmissibility. In VAWA-based adjustment of status cases, you are not inadmissible under the permanent bar or for some other reason that is not accepted or waived. Most of the time, if you only entered without inspection one time or entered legally with a visa that you overstayed and have no criminal history, you can file for VAWA-based adjustment of status. This means that you file your VAWA application, the I-360, along with your application for permanent residence, the I-485. This process generally takes around 2 years, and many of the things that would cause an ordinary family-based application to be rejected, such as entering illegally one time, does not affect a VAWA case. This is the best way to file because you can currently file an application for employment authorization under your I-485. If you do this, then you can be approved for employment authorization, get a social security number, and work legally while your case is still pending. However, there are some cases where a person cannot adjust status because they are inadmissible. This usually occurs when they are inadmissible under the permanent bar. The permanent bar occurs when you live in the United States illegally for a year or more, or you have a removal order, then you exit the United States and re-enter or attempt to re-enter illegally. For almost any immigration application, this is fatal, including VAWA. However, there is an exception to this inadmissibility under VAWA. If you can tie the abuse you suffered from to your second illegal entry, USCIS can waive this inadmissibility in their discretion, and you can file for permanent residence. If you cannot tie the abuse to your second entry, then you cannot have the permanent bar waived for VAWA purposes. However, you are not entirely out of luck. You can still file as standalone I-360 for VAWA. When you are approved, you will receive something called deferred action, which is a defense against removal, and work authorization. It is not an ideal situation, but is better than having no status at all. To summarize, inadmissibility affects the kind of VAWA case you're able to file. If you're inadmissible under the permanent bar, you can likely not file for permanent residence under VAWA unless you can tie your second entry to the battery or extreme cruelty you were a victim of. However, you can potentially file a standalone I-360 to receive deferred action and work authorization. Conclusion. Whichever type of case you have, I strongly recommend that you speak to a competent immigration attorney before you file and use one to guide you through your case. Immigration cases can be complex, and the consequences of not filing your case correctly or filing when you are ineligible can potentially be severe. To summarize, U visas are for victims of crimes, and VAWA cases are for certain abused family members of U.S. citizens or permanent residents. Both are a path to permanent residence, but VAWA is much quicker and provide earlier benefits if you qualify. This concludes my presentation on U visas and VAWA. They are both extremely powerful applications. VAWA is a better application than a U visa. However, if you qualify for both, nothing prevents you from filing for both. I highly recommend using an immigration attorney to file any immigration application. Thank you for listening to this presentation.